Welcome. My name is Roy Sexton. I'm the Director of Marketing here at Kerr Russell. Welcome to our 5 and 15 webinar series. Today we approach labor and employment and immigration trends, and we have with us Kate McCarroll, Immigration Partner, and Catherine Sear, Labor and Employment. We will begin with Catherine, who will review the labor and employment issues, and then hand it over to Kate. Go ahead.
Thanks, Roy. As you've probably seen or read in the news, there have been a lot of stories about sexual harassment in the workplace. Last week, 3 women sued Charlie Rose from CBS for sexually harassing them. But unlawful harassment is not just limited to sexual harassment. Last year, the Equal Employment Opportunity Commission reportedly collected $164.5 million from harassment cases. That's a lot of money, and plaintiffs that are bringing these cases are recovering a lot of money themselves. Back in March, a federal jury here in Detroit awarded a plaintiff who sued his employer for harassment because of his race and national origin $16.8 million. And Uber recently settled a class action for $10 million in a case involving claims of wage disparity and harassment. Because of these cases, and specifically because of the sexual harassment cases, we've been seeing a push to discourage confidentiality provisions. Attorney generals in every state and 2 senators are leading the charge to end arbitration of sexual harassment cases, where arbitration is mandatory. And the Amendment to Tax Cuts and Jobs Act now prohibits employers from claiming a deduction when they settle sexual harassment claims if there's a non-disclosure component. So that means that if you have an employee who comes forward with a claim of sexual harassment and you try to resolve that claim and have that employee sign a release and agree not to disclose the terms of that release, that settlement money is no longer tax deductible. So going forward, the question becomes, how can employers respond and protect themselves from harassment claims? Employers need to review their handbooks to make sure that employees are encouraged to report conduct. That way, employers know about it before they read about it in a lawsuit or a complaint, and they can address and stop that conduct. Employers also need to make it clear that they have zero tolerance for retaliation. We also recommend training your workforce and making sure that your supervisors know what's not acceptable and how they should be responding. Finally, we recommend that you review your arbitration agreements. Even though there is a push now to no longer enforce them if there are claims of sexual harassment, courts are still going to enforce them now. And if you have an arbitration agreement, we suggest that you make sure it covers your employment claims. Another update in the changing world of employment law has to do with transgender employees. Title VII is the federal law that prohibits discrimination on the basis of sex. Previously, courts thought that this law did not prohibit discrimination because someone was transgender. But this March, the Sixth Circuit, which is the federal appeals court that reviews decisions in Michigan, found that a transgender woman could proceed with her discrimination claim on the basis of sex. The court made its decision because it reasoned that discrimination on the basis of transgender and transitioning status is necessarily discrimination on the basis of sex. The court made this decision because it believed that discriminating against someone because they're transgender is in part due because of the belief that that person is not conforming to gender expectations. And because Title VII prohibits discrimination on the basis of gender and sex when someone does not conform to expectations for gender, the court thought that this kind of discrimination then would fall under Title VII. This case was also significant because the employer, which was a funeral home, claimed that they were exempt or had a defense because of religious freedom. But the Sixth Circuit rejected that and said that complying with Title VII is not a substantial burden on religious beliefs, and that it was a government interest to get rid of discrimination. Like the harassment cases I mentioned, this decision is just another reminder that employers need to make sure that they have policies that prohibit all types of discrimination. And employers need to be sensitive when employees announce that they're transitioning. And of course, if employers have questions about how to convey a sensitivity to the rest of the workforce, we're happy to walk you through it. Employers need to make sure that harassment training that they offer covers sexual orientation and gender identity. And finally, my last update has to do with labor law, but again, there's going to be a focus on your policies. Back in 2004, the National Labor Relations Board issued a decision involving Lutheran Heritage Village in Livonia, Michigan. In the decision, the board determined that there was a violation of the National Labor Relations Act because Lutheran Heritage had rules that the board believed could be prohibiting someone from exercising his or her rights under the National Labor Relations Act. Basically, the board was concerned that Lutheran Heritage was discouraging people from exercising union activity or rights under the act concerning union activity. Many of these rules were the kind of rules you might expect to see in a handbook, like rules about civility and keeping things confidential. And what was significant about this decision was that it affected not just employers with unions, but all employers. So even if you don't have a union, if you never had a union, you could still now have to be concerned about this decision and what was in your handbook. The board reviewed its decision in December when it reviewed a case involving Boeing. Boeing had a rule that restricted the use of camera-enabled devices like cell phones. Employees couldn't have these devices on Boeing property unless they had a valid business need. This rule didn't outright restrict this activity prohibited by the NLRA, but it did say that cameras were not allowed unless there was a need for them. Boeing said that this rule was necessary because they needed to maintain confidentiality, and they pointed out that they needed to secure their facilities and their work from espionage by competitors, other governments, and terrorists. So in December, when the board issued its decision, it outlined 3 types of rules. Rules that fell in the first category could now be lawfully included in handbooks, like rules about cameras and civility. But because Boeing is the only decision addressing this new approach to workplace rules, there's still some uncertainty about when policies should be included and why they should be included. So we recommend that you review your handbook for policies that might discourage someone from exercising his or her rights under the National Labor Relations Act. And we recommend that you think really about the business reasons for each policy that prohibit certain conduct. And now my colleague, Kate McCarroll, will share some insight about immigration law.
Thank you, Catherine. The points that I'm going to discuss today are going to be far more general than what has been discussed thus far, and that's for a couple of reasons. Number one, as some of you who are familiar with immigration law know, it is very detailed and very fact-specific. So talking in any great detail about immigration law in the span of a few minutes really is just not possible. And secondly, believe it or not, very little has changed in the world of employment-based immigration. There have not been any new substantive changes in the law, despite the increased chatter. But we are seeing a couple of things that I wanted to talk about today. And first is the Department of Homeland Security is tightening its oversight, and this is done in many different ways. The Department of Homeland Security, or DHS, is the umbrella under which USCIS, Customs and Border Protection, which are the officers at the ports of entry, and ICE, which is Immigration and Customs Enforcement, who are the police arm of immigration and also handle I-9 oversight. DHS is the umbrella over all of those agencies. So you might have seen some of this tightening already across all kinds of immigration. But first is that we're seeing an increased scrutiny of applications, and this holds true for all types of applications, including those made at the border and those filed with USCIS. What worked before simply doesn't work now. What got through without a hitch before is not the case anymore. It really is a learn as you go exercise, unfortunately. We're not getting any kind of advance notice that things are going to be looked at differently. It just happens. So we have to look for patterns and then address what we feel that how they've changed their perception of cases. And very oftentimes you might be seeing that USCIS and Customs and Border Protection are asking for more information than they ever did before. So the takeaway here is to just be prepared. It's going to be a bumpy road and there's no guarantees, so you just need to be ready for that and prepare your employees for that as you file immigration applications. Secondly, is there is an increased instances of site visits and audits. The Department of Homeland Security has always had the authority to visit your workplace. And this is especially true when you have foreign nationals who are working there. They can come to talk to the employee, to see where they work, to check out their pay records, to speak to their manager. This is increasingly so with H's and L's, especially those who might work off-site of your primary headquarters. We also are seeing an increase in I-9 audits. These, in the past, have usually been targeted industries, agriculture, construction, those who have government contracts, simply due to manpower. But this net is widening, and we expect that to continue to be the case. So you can expect that there will be more I-9 audits, and now is a great time to perform an I-9 audit internally. It's actually a great HR training exercise to go through all of your I-9s and make sure that everything is in order, because as you know, every line on an I-9 is grounds for a violation. So if you have any questions in your review of I-9s, please let us know. Or if you'd like us to take a look at any of them, we can certainly do that too. And also for those of you who have E3 or H-1B employees, making sure that your public access files are in order as well. And finally is increased processing times. In all types of applications, we're seeing some instances where these processing times are as much as doubled. This is due not only because of the increased scrutiny that we're seeing, but because there's just an increase in volume of applications filed. As the economy grows, so does the number of applications that are filed with immigration. This is really just about managing expectations. Things are just going to take longer. It might be necessary to use premium processing more than you have in the past. It might be necessary to file renewals earlier, and also to start green card processes for employees earlier, just to make sure that there are no gaps in their ability to work and travel. And then what to do in this uncertain climate. As you can imagine, foreign nationals are afraid, they're frustrated, they are hearing things on social media, in the news, from their friends, so they are on information overload. In addition to their concerns and fear, which they've come to the United States, they've uprooted their family and their life and started a new one here. So, we hear about these a lot. We get a lot of questions about a lot of rumors and friends' cases and how they've gone through processing, and you probably do too. Again, here it's about managing expectations. So the first way to do that, I guess, is you might remember the Schoolhouse Rock song, It's Just a Bill. Immigration is federal law. In order to make changes or implement new law, there is a very lengthy process that bills have to go through. They have to go through committees. They have to be revised and reworked and researched before they can come to a full vote, and then they have to go to the other side of the aisle, either the House or the Senate, and the same process takes place. As evidence of that, we really haven't had any new immigration laws since 1996. And the difficulty of the process is really seen in the DACA fight. There were all kinds of senators and representatives pushing that process along to get DACA to become law, and it just couldn't happen because of all the intricacies involved. So very little ever gets through. It literally takes an act of Congress. Again, nothing has changed. There are no new laws right now. If something were to change, we would have advance notice and could prepare accordingly. And even if that were the case, very little is ever done retroactively. So it would be a change going forward and not necessarily affecting those who had that status or that benefit right now. And finally, as some of you might be thinking, I know there's instances when it's not an act of Congress, and that's true. Some examples of this are the travel ban or DACA. These were done by executive order, which can then be undone by executive order. which happens. And these instances and these types of orders are frequently litigated. We're seeing that with DACA. We're seeing that with the travel ban, which is in its third version currently before the Supreme Court. We are probably the most low-hanging fruit in the world of employment-based immigration is H-4 employment authorization. This is for spouses of H-1B holders who are in the green card process, and these spouses can work with this special employment authorization. We expect that will go away at some point. It too is being litigated. So just to keep in mind, if you have employees who have these H-4 EADs, to make sure that they renew early. Again, this is because if there's a change in law, it probably won't be retroactive. And secondly, to just bear in mind who these employees are, because if it goes away and if they can't renew, those individuals will no longer be able to work. So the two kind of takeaways here are, number one, to prepare to do those internal audits of public access files and I-9s to make sure that everything is in order, and to prepare and file things early just because things are taking longer. And secondly, to manage those expectations. There is going to be increased scrutiny. It's going to be a bumpy road. There's going to be more denials and more things asked. So it's really just preparing employees, their managers, and the HR staff to know that these are normal things that are just going to take place in this new immigration climate.
Thank you, Kate. Thank you, Catherine. Today we heard from Kate McCarroll, Immigration, and Catherine Haseer from Labor and Employment. If you would like to follow up with either of these attorneys, please visit our website, www.kerrussell.com. That's kerrussell.com, or give us a call at 313-961-0200. Thank you for listening, and we look forward to having you join us for future webinars and podcasts.